All right, and you will see up on the top left of your screen, it should say live on YouTube. And again, that's a very limited purpose. But we're here this afternoon on the plaintiff's motion for reconsideration. And so I'll begin just by welcoming y'all. And Mr. Thompson, would you like to begin?
I would, Judge, and it's good to see you.
It's good to see you.
So I'm gonna, I'm sure you read the motion or motions and the motion for reconsideration. So I'll be brief on this. Basically, Judge, under the law, there's two different reasons why such a motion to add parties should be granted. The one is, will it prejudice the new parties? And in this, I don't believe it would, because I think these parties have really been part of this all along. And secondly, what's the justification really for not listing in the original suit? I didn't know about their tortious interference until these depositions. And I did receive a contract from, showing that they'd hired the defendant, Longlake HOA Association, hired this company, Riversand, but didn't really know about Riversand contacting repeatedly the defendant until the depositions. And so just to go back a little bit, there was a period of time where we agreed to extend or we did a consent to extend the scheduling order, Judge, because I was hospitalized with COVID. It was pretty rough. I about died, literally. When I came out, even to this day, I mean, I'm not hitting on all cylinders, I don't think, but I don't know if it ever was, but it took me a while really to recover. And we also had a lot of depositions to do. And so we extended that to get all these depositions in. Even after the time, we still did some depositions because we needed to get them in. And it was, it was still ongoing. And I didn't find out until later on about the contact between Riversand and Long Lake as far as the interference, the calling them and getting involved. And what's important here is that Riversand was the only other bidder. So it wasn't, in my mind, I'm partially thinking, well, they just got awarded the contract because they didn't like my client. They got somebody else. But I didn't find out about what really happened. There's more of a conspiracy type of thing going on with the interference and then their hiring until these depositions, which were later on. I can't remember when I put it in the motion here, I think. I didn't even the new president of Riversand, Jimmy Mouton, I wasn't even able to, I didn't even have the transcript of the deposition at the time when I filed this motion to reconsider. That's how late into this was. And that's really it, Judge. I mean, I think they were part of this all along, and they deserve to be part. I don't know how they'd be prejudiced when they're a part of this, the ongoing lawsuit to begin with, it seems. And I don't know for sure or not if John represents Riversand. It's possible, but I'm talking about John Schwartz, opposing counsel. But at one time, there was a meeting, I found out in the last deposition, between Mr. Schwartz, Riversand, and Longlake HOA Association for a new contract that was signed in, I guess, February of 2021. But that was after the prompting by this person, John Bryan of Riversand, found out through the deposition of Stacy Soros, who said that he called them and wanted to, and they're not even close in the area. They live like in Cleveland, Georgia, called her and then showed up on site and this is in Forsyth County, to basically complain about my client's work. And this is what I found out during the depositions, again, which were later on during the whole process. And that's why I'm asking that they be added as parties, Your Honor.
Okay.
And by the way, just I wanted to introduce you to Hanaya Borders. She's helped me. She's a junior at Georgia State. She's thinking about going to law school, psychology major. I'm good friends with her dad, one of my best friends. And this is the first time she's done any court-related thing probably ever, right?
Yes.
Yeah. So
Well, welcome, Ms. Borders. It's nice to meet you, and I'm thrilled you're having an opportunity to observe. And Mr. Thompson, I want to make very clear that I could not, both personally and professionally, be sorrier that you've had a hard time. And I certainly want to say that you've always had the court's utmost respect. But I'm terribly distressed that you have not dealt well.
I appreciate that, Judge.
Okay, Mr. Schwartz.
Thank you, Your Honor. And just to clarify, I do not represent Mr. Bryant or River Sand. They're most fundamentally here, throughout the various briefs that U.S. Aquavac has filed, they still haven't identified any conduct that arises to the level of tortious interference. So they've stated that Mr. Bryant contacted Longlake HOA, but there's never been any contention that they said anything that wasn't true or anything else that arises to the level of tortious interference. So it's just really the statements that they've said about what he's done wouldn't even hold up to a motion to dismiss under Rule 12b-6 for failure to state a claim. They just haven't identified the prima facie elements of a tortious interference claim. Even if there was enough alleged to have a tortious interference claim, that's a completely separate claim than what we're dealing with here. And so the purpose of joinder is when complete relief cannot be afforded to those who are already parties, and the party to be brought in claims some sort of, or the party who's sought to be brought in claims some interest or related to the subject matter of the case. And we don't have either one of those here. So there's really no reason for them to bring them into this case. And I don't even know how they could bring them into this case procedurally, because I don't think that River Sand or John Bryant are residents of Fulton County. And it's not alleged that River Sand or John Bryant are joint tortfeasors with the HOA. And while a defendant could implead a third party into the case when that party may be responsible for some part of the judgment against the defendant, that's allowed, where you can bring a third party into the case without having proper venue otherwise. But there's no provision to bring a party in under these circumstances for venue, even if they did have a claim. Aside from that, and I've worked with Mr. Thompson throughout this case to be cooperative and try and accommodate his schedule, and haven't objected to any extensions we're after discovery has expired. We're into March 15, and we're supposed to be on a pretrial for next month, and I'm on a trial calendar for May. So I don't even understand how this would work. Would whether the existing parties would go through further discovery, or River Sand would have no discovery. But it could have been brought to the court's attention earlier. I mean, we had identified Mr. Bryant and River Sand in April of 2021. We'd already and it stated that Mr. Bryant observed the sediment being moved into a deeper part of the lake. It's just a completely unrelated to to the claims that are in this case. They're, U.S. Aquavac filed a breach of contract claim against the HOA. We counterclaimed for breach of contract and for some torts. And it's just, there's nothing about any of the claims between the existing parties that couldn't be resolved without river sand. It's just a different issue for a different case. And let me see. Let's see, People's Bank of LaGrange, which was in our brief, the court said that the primary consideration on joinder is whether a judgment that might be rendered will be adequate in the absence of the party sought to be joined. Here, that's true. There cannot, there would be complete satisfaction of any judgment without river sand. They're not in any way helping either party on the judgment on the claims that are already brought. It's just unrelated claim that they're trying to bring in. And the determination of whether the judgment made is adequate in the absence should be made without looking at a claim that could be had against the third party in a separate case. That's just, it's not relevant to the determination of whether to bring them into this case. And it's all been briefed. The court got it right on the first time, and there's really just no new information that was brought in on the motion for reconsideration. Mr. Thompson claims that there was that Mr. Mouton, who's the current president of the HOA, testified in a manner that's different than what Stacey Saros, the prior president of the HOA, testified to, but it's not true. What Mr. Thompson was stating in his motion for reconsideration is that he's claiming that Mr. Mouton was testifying differently than Mrs. Saros, because supposedly that Ms. Saros had testified that the HOA had not hired anyone else after the contract was terminated. That was what he was trying to say was new information, that he says that in the Saros deposition, which was first, that she testified the HOA had not yet hired someone. And then in the Mouton deposition, that he testified that someone was hired. Now, Ms. Saros never testified that that the HOA didn't hire another company. Again, that was disclosed to U.S. Aquavac in February of last year when we provided the river sand contract. What Ms. Saros was asked was whether dredging had actually started. That dredging has not started, but there was a contract entered. So there's no conflict between the testimony of Ms. Saros and Mr. Mouton. It's just, there's nothing new. And it's just, I think Mr. Thompson misunderstood the testimony, and we asked that the motion for reconsideration be denied. Thank you, Your Honor.
Okay, Mr. Thompson, I'll let you have the last word, sir.
Sure. It is true that obviously that any, like that river sand could be sued in a separate lawsuit. There's no doubt. However, again, didn't find out about the conversations that happened until the deposition. In other words, we knew that there was a contract. We knew it was river sand. We didn't know that river sand was actively contacting Longlake HOA Association until the depositions, which were way late into discovery because of not only my COVID, but COVID in general and everything else going on. And, I know it's been 2 years, Your Honor, but, it's been a strange 2 years. And I think, I don't see other parties would be prejudiced if they're added and deposed. I think we could get it done pretty quickly, considering that it looks like they've been part of this case all along. I don't think venue actually comes into play here because the venue is it's already the original party was already sued. They would just be joined. So that, that's why I'm asking, Judge. I mean, I think it's pretty straightforward, but I'll leave it in your hands.
Okay, well, I appreciate that. And again, I want to be very clear up front that I am terribly sorry. And I'm not just saying that. I have very high regard for you, Mr. Thompson. And I could have picked a lot of other people that I would have rather seen hurt other than you. But here's the central thing in looking at the original motion that was filed in December, the court's order, and then the motion for reconsideration led me to the sentence in the original motion in December that just said you found out about John Bryant of River Sand during discovery. And accordingly, those were the people that you wanted to add, or those were the entities, people that you wanted to add because they had tortiously interfered. That is the same argument, from my view, that you're making in the motion for reconsideration. You're just saying, well, we knew about it and we thought that, and therefore we wanted to add them. And now we really know about them. And court, we want you to reconsider. And so respectfully, the court declines that request. I'm denying your motion to reconsider. Ms. Borders, this is an excellent example of having to enforce the law when you really, really have a lot of respect for the people involved. So, Mr. Schwartz, will you prepare an order and submit it, please?
Yes, Your Honor. Thank you.
Okay, is there anything else I can do for you guys?
No, Your Honor.
Okay.
Hey, one thing before we go. If you notice, I'm like one of the only Republican lawyers that's not getting sued. Or
Mr. Thompson, that's why I prefaced everything with great respect, and I have enjoyed working.
You too.
And
Good luck
we'll
with
look
I saw your signs up. Good luck.
Well, thank you. I look forward to getting this one across the finish line. And you guys could settle. And if I can help in any way, you let me know.
Thank you, Your Honor. We appreciate that.
Judge.
Okay, nice meeting you.
You too.
All right, thank y'all so much. And now I've got to take us off YouTube before I stop it.
Oh yeah.
So y'all don't get marriage proposals from Australia.